practicing, practicing lawyer and mediator in Supreme Court. In this International Virtual Mediation Summer School 2022, conducted by Nivaran, mediators of Supreme Court of India, Nivaran has kept a bucket full of beautiful and different flowers. For last 5 days, we are being given one flower each day, which has its own fragrance. And today is the 6th day, as you know. And we are being given a beautiful flower having its own fragrance and lovely and mind-boggling fragrance. With a new beautiful flower, we are going to welcome today's session. And you all must be very keen to know the name of the flower. And the name of the flower is Negotiation today. Today we are going to hear from Mr. Jawad about negotiation. What is negotiation? Kinds of negotiation. The negotiation skill of a mediator. How can mediator facilitate and not negotiate also? Late conclusion and agreements in mediation, etc., etc. Before becoming a mediator, I used to think that mediation is not negotiation. I used to feel no, mediation is something different from negotiation. But later I came to know when I became a mediator that no, negotiation is also an important part of mediation. As per my understanding, negotiation is communication for the purpose of persuasion. It is a process of negotiation. It is an assisted negotiation process, I'll say. It is the process of back and forth communication aimed at reaching an agreement between the parties to their satisfaction as possible as to both the parties. It involves a complex set of human behavior requiring an understanding of communications, persuasions, marketing, decision-making, and behavioral theories. Psychology also, economics, assertiveness, conflict resolution methods, and above all, flexibility and creativity. Mr. Kerry Fisher has rightly said that everything is negotiable. Whether or not negotiation is easy is another thing. It is not a new concept. It exists from ages. Remember, Lord Krishna has also tried to negotiate between Kauravas and Pandavas before the battle of Mahabharata. We keep negotiating from morning till night. We sleep. Wherever we get a chance to negotiate. At times we negotiate with ourselves also. It may be vendor, family members, ourselves, in market, everywhere, in any manner, it may be soft, hard, and or perfect. Given a chance, we would like to negotiate with anybody and everybody. Let's hear more and in details about negotiation from Mr. A.J. Jawad. Mr. Jawad doesn't require any introduction, at least today at this platform. To introduce him is like, I'll say, showing light to the lamp. Yes, he is very well-known name in the field of mediation, or say in ADRs. Mr. Jawad did his law from University of Madras. He practiced as advocate before the High Court of Madras. He became a mediator, and in 2007, and since then he is practicing as a mediator also. He has trained with ADR, ODR International, underwent additional training in mediation, and the ADR Group UK organized by the British Council training. He has extensive experience in mediation of commercial mediation, contractual mediation, matrimonial and child custody cases. In fact, I'll say today, he is one of the most desired names as a mediator in and outside India. And now, he's a trainer with MCPC, Supreme Court of India, and has trained and is still training lawyers, not only lawyers, but judges in mediation all over India. He has conducted several POTs also duties workshops for the MCPC. Mr. Jawad is an accredited digital dispute resolution specialist with ADR ODR International UK. He is accredited as a SIMI Level 3 mediator. He is empaneled as mediator and global faculty with ADR ODR International UK and with SIMC as an India specialist mediator. He is a panel mediator with Bombay Chamber of Commerce. Mr. Jawad is also empaneled as an arbitrator with the Madras High Court Arbitration Center, accredited trainer and mediator with the Tamil Nadu Mediation and Conciliation Center, High Court of Madras, and the Mediation and Conciliation Project Committee, Supreme Court of India. He is the special guest faculty for the Madras, for the Masters in Mediation PG course of Maharashtra National Law University. Mr. Jawad is a professional affiliation partner and head of ADR services with KDLX Chambers, a firm offering a range of ADR services. Before I hand over to Mr. Jawad, I would like to introduce Mr. Rakesh Khanna, senior advocate and a leader and ex-president of Supreme Court Bar Association. He has been a constant support of Nivaran along with other distinguished senior advocates. Like Jawad, he also doesn't need much introduction because he's a well-known personality here in Nivaran as well as in the field of our advocacy profession. Both of us will be conducting question and answer sessions also, and thereafter he'll give his closing remarks. Mr. Jawad, I hand over to you. Please guide us and enlighten us on the subject negotiation. Mr. Jawad, hand over to you.
Thank you so much, Manjula. Thank you, Nivaran, for this opportunity. A special thanks to Mr. Rakesh Khanna, Mr. Rajiv Datta, Mr. Jitendra Sharma, my friend Santana Krishnan, and to all of you for being present here today to listen to this discussion. Normally, I'm very uncomfortable with the lecture format, but there are too many people here, so I guess the discussion may not be possible. But by the way, I wish to really thank Manjula, because when she was talking about flowers, I thought she was referring to me, but fortunately she was referring to the subject. So I was just beginning to blush, and then I realized, well, I am not the flower here. So thank you, Manjula, for that. And also for declaring how notorious I am all over India. So thank you so much. So friends, I'm just going to share my screen. So we are going to be talking about a very interesting topic called negotiation. I'm supposed to speak for 45 minutes. I hope I'll be able to hold your interest for 45 minutes. And if in case in my excitement I exceed the time, please forgive me. So I'm just in advance, I'm apologizing to you for in case I exceed my time. Let me just share my screen. Okay, here goes. I hope you can see my screen.
Yes.
Yeah, so the question is, what is negotiation? How would we define negotiation? Which I think as a starting point for the discussion, I think it is relevant and it's important that we understand what is the meaning of negotiation. Now, the dictionary meaning of negotiation is, 1 minute, the process of discussing something with someone in order to reach an agreement with them. So this is, I think it's in Cambridge, I think it's Merriam-Webster, all the dictionaries have a sort of a more or less overlapping definition of mediation. To negotiate has a slightly different connotation. It says to deal with something difficult. For example, to negotiate mountain pass, to negotiate heavy traffic on the road. You can give an example of the company having to negotiate with some difficulties in its first year of business. Now, when you read this negotiation and to negotiate, the negotiation part of the definition also contemplates the existence of some kind of a problem, or maybe a situation that needs to be discussed and needs to be resolved, and an agreement has to be reached between the people who are involved in that. Now, apart from this definition, there's a very interesting book, Getting to Yes, by Roger Fisher and William Ury, whom I'll be referring to a little later also. They define negotiation as a back and forth communication designed to reach an agreement when you and the other side have some interests that are shared and others that are opposed, as well as some that may be simply different. So essentially what they are saying is it's the communication that you engage in with the objective of reaching an agreement when there is something that is shared with another person or group of persons, or something that might be opposed, or something that might be different also. Now, mostly negotiation gives us the jitters, right? When you have to negotiate with someone, especially when you're in a conflict situation, when you're facing a problem, and it requires you to negotiate with someone, it gives you the jitters, right? And who better to express it than the Simpsons? So why? Why does it do that? Because as you can see from this picture, in our minds, we are planning an attack and a defense. So what are we going to, how are we going to attack the other person? How are we going to defend ourselves from the attacks that might come from the other person? So this is how we look at negotiation, and perhaps that is the reason why it gives us the jitters. And the question is, does negotiation have to be a fight? Does it have to be something that I need to win? Does it have to be a competition or a battle of wits, or some kind of a fight where one person has to win and the other person has to lose? Why can't it be a dance? Now, you know what happens in a dance, right? There is synchronization, there is harmony, there's a lot of movement, there's a lot of energy, but you enjoy it. When you're fighting with someone, in a fight, like let's say a boxing match, you see a lot of blood, you see a lot of injury that is happening to both parties, both sides who are sparring or fighting with each other. In a dance, that doesn't happen. And there's this very beautiful video that I saw of an elderly couple dancing that I just want to share with you. Please tell me if you're able to see. Sorry, I don't think you could see the video. Could you see the video? Let me share the video separately. Sorry to interrupt that, because it lasts for about 2.5 minutes, and that is precious time when you have only 45 minutes to discuss quite a difficult subject. No, but you could see the harmony of it, right? The synchronization, the beauty which came out of it, how much the couple were enjoying dancing, doing the dance. So why can't negotiation be something like that? Why should it always be something so difficult or so tough? That it has to be a fight. Now you see the picture of a car. The Mini Cooper happens to be my favorite car. Let's imagine that I'll just give you an example of the kind of negotiation that we normally indulge in. Let's say that I want to sell this car, and my friend Santan finds out that okay, I want to sell this car, so he comes to me and says, "Hey Jawad, I want to buy this car from you." And now what happens? Santan is a good friend of mine, and let's say that I expect about 100,000 for this car, $100,000 or 100,000 rupees or whatever currency. Let's say 100,000. I expect to get in the market for this if I put it up for sale. But now Santan is my friend, and I don't want to tell him the price. And he asks me, how much, Jawad, will you sell this car to me for? And I tell him, Santan, look, since you're buying it, you tell me the price. We are good friends. And I don't want to make this a commercial transaction. I don't want to tell you any price. This is what is going on in my mind. And I tell Santan, look, Santan, whatever you give me a reasonable quote. And Santan says that, Jawad, I know your car is a good car, but my problem is my budget is about 60,000. So what do you say? And I'm in a dilemma now. I don't know what to do because Santan is my friend and I can't tell him that, Santan, that's too low. That's not what I expect. So I tell Santan, fine, Santan, no problem. Please take it. And I give it to him. But what happens is I'm feeling deep down a little sad because I've lost almost 40,000. And I feel that I have been too soft. But I don't mind because, Santan is my friend. And for me, the relationship is very important. And not the money part of it. And I want Santan to feel good about it. I don't want to, disrupt our relationship in any way by bringing the factor of money into it, and don't want to indulge in any kind of negotiation with him. So I keep quiet. Okay, so I just give the car. Now imagine a situation where for this very same car, somebody who doesn't know me, okay, I advertise for this car, and somebody who doesn't know me comes for this car and says that, how much is this? And I say that I want to sell it for 100,000. That's my base price. But I hike up the price. I say 120,000 is what I'm expecting for this car. And I tell him, look, this is, brand new tires, and, my painting is still intact, not a scratch on the car, and it's performing very well. It's got a fantastic mileage. It's got a brand value, blah, blah, blah. And the other person says that, hey, look, come on, this is, the new car costs about 130 or 140,000. So why should I pay you that much? And here's what I would offer you. I would offer you, let's say, 80,000. And then it goes back and forth, and I argue, I debate, I discuss, and then finally, maybe I agree at 90,000, or maybe he agrees to give me 110,000. But either way, one person wins and the other person loses. So this is one way of negotiating. Okay. So what we call this is, what is the soft negotiation, the one that I did with Santan, and the other is the hard negotiation, the one that I did with the stranger who wanted to buy my car. So in soft negotiation, the intention is to avoid personal conflict, make concessions readily. The objective is an amicable resolution, but in the process, there's every possibility that one may end up feeling exploited and bitter. In a hard negotiation, it is a contest of wills. You take extreme position. There's a desire to win, and you end up feeling exhausted, and there's a damage to relationship. Now, does negotiation have to be either soft or hard? That is how negotiations used to be at one point of time. And it also depended on the personality of the people who are involved in the negotiation. Sarah Blake had spoken to you about this in the context of conflict. Thomas Kilman conflict modes, where she explained to you that how we approach conflict. So this is also how we approach a negotiation, because we see if you look at the graph here, the red arrow is the assertiveness. So the higher you go in this, the more assertive you are. You're more competitive, and you're more focused on your needs and desired outcomes, and whatever your agenda you want to fulfill it. Whereas if you see the yellow arrow, the more it increases, where it points towards, it's more cooperation. So what is important for you is the other person's needs, and you value the relationship much more. So what happens in the negotiation is you avoid a confrontation. You want to avoid any kind of prolonged negotiation. You want to maintain neutrality. You withdraw from the situation. You accommodate the other person's request in a soft negotiation. You accommodate the other person's request, and you are more focused on maintaining the relationship, maintaining the harmony. Okay. Now, in between this and that, there's something called a compromise, which is neither here nor there, where you can, simply agree that, okay, it's a kind of a 50-50 situation. I'm sure all of you would have heard of this age-old orange story. But anyway, let me repeat it in case somebody has not heard of that story. I would be surprised if you have not heard. So here were two kids who were fighting over an orange. And for some reason, they had only one orange in the house. And they go to the mother. Now, what is the mother going to do? If she cuts the orange and gives it to one half to each child, she will be compromising. So is compromise always good? That's a question. So why don't we think of something more? So before that, let me just point out about the competing, because you are very competitive. It's my way or the highway. You're very assertive. You want to, either it's going to be on your terms or it's not going to be, there's not going to be a deal at all. So if one of the child takes a stand that I want the entire orange and I'm not willing to share it, that child is very competitive. Now, what happens if the mother or the children, they ask each other, why do you want this orange? And one child says that, okay, I'm planning to make marmalade out of the rind, so I need the rind. The other says, I want to make juice out of the pulp, and I want the pulp. So there you have sort of what is commonly called as a win-win outcome. So you're expanding the options, and basically you're collaborating with each other. So in a negotiation, whether should we have a soft negotiation or should we have a hard negotiation, which is the competing kind of negotiation or a compromising kind of negotiation, or should we have a collaborating kind of negotiation? Now, this is where these two gentlemen came into the picture, Roger Fisher and William Ury. And it is their definition of negotiation that I read out to you in the beginning. So they said, look, you don't have to be soft, you don't have to be hard. There's a better way of doing things. So why don't we have what they called as principled negotiation? Essentially, what is principled negotiation? Now here you see a picture of these two people trying to cross over this deep chasm that is there between them on their way, and they've kept a plank and they're crossing it. Now, normally how we perceive negotiation is that imagine that these two are standing on the opposite side. Now, either one has to go to the other side or this one has to come to this side. But principled negotiation helps them to understand that, look, both of you are one side, and the problem is this gap, is this huge chasm that is there, which you need to cross together. So this is basically the objective of principled negotiation. So what William Ury and Roger Fisher said was that for a principled negotiation, you need to understand one, that people in conflict or people who have a problem or people who are in a situation which they need to negotiate and reach an agreement or they need to overcome, they always identify the other person as the problem. So if two partners are fighting with each other, one partner says, well, the other partner is a cheat, he's a fraud, he doesn't maintain the accounts properly, he's not transparent and honest with the customers. And the other person says that this man is a useless businessman, he doesn't know how to conduct a business. So they identify each other as the problem. So what they say is you separate the people from the problem. So what is your problem now? Is it each other? Or is it something more than that? Is it something that you need to have a process or need to agree upon how this business is going to be run? And doesn't that require both of you to sit and talk to each other? So separate the people from the problem. Focus on their interests, not positions. We all come with positions. It's always been, a fantasy for me that I should get married to Salma Hayek. Now that's my want. Now, my wife tells me that, look, I don't think she's reachable for you. And you have me here. So we decided to get married. Okay. So what I need basically, what is my real interest? I need a person who loves me, who cares for me, who would be willing to live with me, and perhaps grow old with me. So my real interest is to have someone in my life who really cares for me, right? Sorry, I'm just giving you a very rough example for this. The third thing they said was, don't focus on only one option, because we always approach a negotiation with a fixed pie assumption. We think that, okay, this is the pie, this is the piece of cake that needs to be divided. They say that don't get stuck on that. Invent multiple options. Think of different options. Evaluate those options. And decide which option is best for you. Because every problem need not have a single solution. It can have multiple solutions. So examine those multiple solutions, start thinking out of the box. I was doing this mediation a few years back, okay, where this is an example which I usually give in my training programs too. I hope it is relevant here too, where, there was this a suit filed by a multinational company against an Indian company for recovery of money. And the facts of the case were that this Indian company was in the business of leather processing, tanning, processing of leather, and coming up with the finished leather, which was exported. So for this, they had purchased a lot of chemicals from the multinational company. And there were invoices, there were orders placed, there were invoices, the delivery, proof of delivery was there, and the checks that were issued towards the payment were there. But unfortunately, the Indian company was on the verge of bankruptcy, and they could not, they were in no position to pay. And what happened was, as we were discussing about the prospects of this company and the prospects of recovering anything from this company, it so happened that we came to know that the managing director of the Indian company was a very influential person, in the sense that he had been the president of the Council for Leather Exports for a continuous period of 3 to 4 years. And he virtually knew everyone who was in the leather business, the who's who of the leather field in India. And he was on first name basis with all the CEOs, with all the managing directors, and he had tremendous contacts. And here's what something surprising happened, because the other company came up with a proposal. They said that, okay, look, we realize that you're in a bad situation where you are not able to pay us, though you have the intention to pay. And here's what we can do. We are trying to establish a market here in India. So why don't you take over as a distributor or our agent here and canvass the business for us? And we will fix a commission for you. And from that commission, we will take whatever is due to us and pay you the balance. And this was agreed upon. So something which was totally out of the box, something that could not have happened in the court. Now, that was one option. Now, what William Ury and Roger Fisher say is, don't restrict it to one option, because if that doesn't work, your negotiation fails. So why don't you come up with multiple options? Evaluate those options, test those options, and then agree that which is the most workable one for both sides. And insist on objective criteria. So whenever you evaluate these options, It should not be, because we all suffer from different biases. We have what is called as an endowment bias, where what belongs to us, we value very highly. We have what is called a reactive devaluation. If it comes from somebody else, we devalue that. So understanding the fact that we suffer from all these biases, they say that when you're evaluating an option, when you're evaluating an offer, apply some objective criteria that is common in the usage or in the custom, which is related to that particular issue that is being negotiated. So they called it as principal negotiation. So 4 things. 1, separate the people from the problem. Don't treat the people as the problem. Be soft on the people, but hard on the problem. Focus on their interests, because when you transcend interest, we'll be seeing that shortly, how it works. There is usually an overlapping of interest. Now, if in the example which I gave you, if you see, now the position of the plaintiff company is that I need to recover my money. And the position of the Indian company, sorry, I can't pay you. Now, their interest is, how do we carry on the business? How do we continue? How do we expand? How do we grow? So that is their interest. So you see, there is an overlapping of interests, right? And that is where the zone of possible agreement emerges. Focus on, try to invent multiple options and insist on using objective criteria. Now, they describe what is called the pin pyramid. Positions is what we say we want. Interest is what we really want. And needs what we must have, without which we cannot live. Okay, so needs are something that we can live with. So once we understand the interests by asking those questions, why is this important for you? What happens if you don't get this? Is there anything that would help you to meet your needs? So these questions will disclose what is their interest. And once you identify the interest, how do you fulfill those interests? What needs to be done about that? What are the needs? And this is where you see this gray area over here. This is called as the zone of possible agreement. And this is where you find that there's a lot of overlapping. When you see the interests, or you see these 2 things as 2 different peaks, where people are standing on 2 different peaks, and there's no meeting point. But as you come down, as you approach this valley between these 2 mountains, you realize that, okay, there's an overlapping of interest, and the needs are something that would provide you the solution. So what needs to be done today? Or what is the need of each party? How do you fulfill those needs? Now, the negotiation process is something that cannot be ignored or neglected. You can't just jump into exchanging offers or making or rejecting offers. You have to go through a process. First is preparation and planning. So when you're preparing and planning for a negotiation, you need to have a strategy ready. You need to understand what your interests are, what your goals are, what is it that you're trying to achieve, and what could be the goals and interests of the other party. It's not just about you. Negotiation is all about reaching an agreement that would be workable for both sides, something that both can live with. It may not be the best, but it should be something that both can live with. So a lot of preparation and planning is required. So you need to go down into examining what is most important for you. What is the deal breaker? When do you walk out of the process? What happens if you walk out of the process? So you go for a negotiation being fully prepared and with a lot of planning. Once you enter the negotiation, you lay down ground rules. Okay. Now, you need to define what is the scope of the negotiation. What is it that we are going to be talking about? What are the issues that we need to resolve, we need to discuss and resolve? And what are the rules that we are going to follow? Are we going to communicate with each other angrily, or are we going to communicate with each other observing a certain level of politeness? Are we going to listen to each other? So have the ground rules ready. For example, uninterrupted talking time for each person, and while the other side listens. and tries to understand where exactly they are coming from. So lay down the ground rules and make sure that the exchange is polite. Clarification and justification. Clarify why you want this, or why you need this, and why this is important for you, and what are the reasons for that. Then you come to the bargaining. Now, many people confuse bargaining with negotiation. Bargaining doesn't capture the whole picture of negotiation. It is only a part of negotiation. It is not negotiation per se, but it is one part of negotiation where it is always on the price, on the value. The bargaining always happens on the value. Like, for example, if a landlord and tenant are entering into a negotiation, first they negotiate on whether the landlord is willing to give the premises to the tenant. Then you discuss for what use is that tenancy going to be, whether it is going to be residential or whether it's going to be commercial. Then you discuss what is the tenure, how long is the tenancy going to last. And then you discuss that what are the obligations of the landlord and what are the obligations of the tenant when it comes to the maintenance of the building. How about the sharing of the common areas? Once you decide all this, then you start bargaining on the rent. So I would like to receive a rent of 5,000 or 10,000 per month. And then the bargaining starts and the other person says that, look, I cannot afford that. I can pay you something less than that. And problem solving. So this is when you really go into the problem solving. And then comes the closure, where you reach an agreement. And the next part of it is implementing the agreement. So negotiation has to follow a process. You cannot jump from one stage to the other stage without defining or without understanding what you have done in that stage. So after every stage, you stop, you pause, you summarize, you agree that, okay, this is what we have agreed upon and this is how we are going to proceed further, right? Now, what is more important for us in the context of today's discussion is what is the mediator's role in the negotiation process? Obviously, mediator is not a negotiator, but mediator nevertheless is the facilitator of the negotiation process. Now, as a mediator, it becomes very important for you to understand what is the negotiating style of the party. Are they being accommodating? Are they being competing? Are they being compromising? They have very little time. They just want to get it done and move on with that. Or are they collaborating? And if they are not collaborating, how do you make them collaborate with each other? So what is that you do to take them to that stage where from competing or from accommodating or compromising, they move on to become collaborating? So what kind of questions you ask? Now, that is something that will be dealt with perhaps in more detail in one of the other sessions that you will be having, because my scope is limited to talking about negotiation and mediation in the context of negotiation. So basically the mediator's role, what is the mediator's role? Now, in order to be able to facilitate the negotiation, it becomes very important for the mediator to understand what Roger Fisher and William Ury call as the 7 elements of negotiation. So broadly classified, they are the connecting elements, the choosing elements, and the crafting elements. Now, as you can see from the picture on the right, as a mediator, you first explore what is the relationship between the parties. Is it something personal? Is it legal? Is it contractual? Is it strong? Is it weak? Is it something that needs to continue? Or is it something that needs to come to an end? So you try to explore what is the relationship between the parties. And then you try to understand how the communication has been between them. Has the communication been there at all? Because the moment a conflict arises, the first casualty is communication. So how is the communication between the parties? How do you restore that communication? How do you structure the process of communication between them? Now, once you have done this exercise, you come to what are their interests, because you start exploring their interests. Then you start generating options and you start testing those options, the legitimacy. That is the objective criteria that we spoke about. So once the relationship and the communication have become very clear, then comes the next, those are the crafting elements where you discuss with them what their interests are, why what they are asking for is important for them. whether that can be, substituted with something else. What happens if they don't get it? So all these things you discuss, these interest options and legitimacy. Now, here we come to a very important aspect of that, the choosing elements. Now, why would the parties choose those options that are there between them? Why would I choose to resolve something through a negotiation or a mediation when I can get something better out of that? What happens if I walk out of this negotiation today? What do I get out of it? So that discloses my BATNA, best alternative to a negotiated agreement. Now, if my BATNA is very strong, why should I settle? Now, if my BATNA is strong, but my VATNA is stronger, the worst alternative to a negotiated agreement. One of the examples that I can give you is, I feel that I have a very strong case. Legally, my case is very sound, and my lawyers have assured me that I will get the relief in the court. That is my BATNA. Now, the question is, how long is it going to take me to realize that? And is getting a decree the end of my problems? How am I going to execute the decree? How am I going to realize the money that is due to me? Or how am I going to realize the relief that is due to me that the court may perhaps grant me? How much is it going to cost me in terms of money, in terms of resources, in terms of the time that I'm going to spend? How much havoc is it going to cost me in my life? So, is my BATNA really strong? Or is my BATNA stronger than that? There are many other things like Malatna is the most likely alternative to a negotiated agreement. What is a realistic alternative to a negotiated agreement, which we call as the RATNA? So this evaluation is done with the help of the mediator. The mediator helps the parties to evaluate these things, to see how these things are going to work out for them. And if they say no, you explore the alternatives. If they say yes, what is their commitment? How committed are they to what they have agreed upon? Are they going to go back on that? So are they able to fulfill that? Will they be in a position to fulfill their commitments? So this is what a mediator basically does. And in order to be able to do this as a facilitator of negotiation, it becomes important for the mediator to be aware of the 7 elements of negotiation. So essentially, a mediator's role. One, the mediator serves as a neutral facilitator. You're not connected with either party. You're neutral and you're merely a facilitator. You're not an adjudicator. You're not an evaluator. You're not going to tell the parties what to do, what not to do. You assist the parties in generating the options, in clarifying the options, and testing those options. You summarize and restate and prioritize the issues. What are the most important issues that the parties need to address? What is important for them? What their real interests are? So you keep summarizing, restating, and prioritizing that. You enforce the ground rules. Sometimes people get angry. They may lose their cool. They may start shouting at each other. So you lay down the ground rules and you enforce those ground rules. You evaluate the options and the possible consequences. What happens if you test the option, basically. We sometimes call it the SMART test, whether the option is something that is specific, that is measurable, that is achievable, that is realistic, and whether it is time-bound or not. So you evaluate those options and what are the possible consequences? What happens if this option is implemented? Is it realistic? Is it something that can be done? And what happens if it is done? How does it affect the parties? How does it affect them in the long run? Because mediation is all about the future. So then you help them to identify areas of mutual interest. As we saw, in interest, invariably, there's an overlapping of interest. So that is where the zone of possible agreement arises. So you help them to identify those mutual interests. So this is what basically a mediator does. Okay. Now I'm stopping here. So I have just briefly covered what principal negotiation is all about. And if there are any questions on this, perhaps we can discuss and then develop further based on those questions. Manjula, over to you.
I'll request all the participants, if they have any question till now, they can put in the chat box and we'll take that, and Mr. Jawad will answer. So please, whatever questions do you have, please put in the chat box.
Chat box, or you can even raise your digital hand and ask the question.
Yes, you can raise your hands also. We'll unmute you. Mr. Jawad, I would like to ask one thing which I could not understand properly. You were saying about Batna in this negotiation process. So there are, you used some word that there is something more than that. That was, what was the word? Something you used.
Batna.
Follow Batna. Okay.
Batna. Worst alternative to a negotiated agreement.
Okay, no, I understood. I misunderstood that. So I was not able to understand properly.
Yeah.
Yes, sir.
Yeah, I see one question from Mr. Rajput. In negotiations, there is this concept of chips and chops. Can you please briefly explain with the example? No, sorry, Mr. Rajput, I have not come across this so far. If there's somebody else in this meeting who can explain this, well and good. But I don't know really what is chips and chops.
Right, Mr. Rajput, come over and explain the concept, then you can answer further.
Well, sir, I have a little brief idea about chips and chops. I just wanted to reinforce my thoughts on that. In fact, I had learned it from one of the negotiators. It's basically chips are bargaining offers, and chops are the threats in that particular offers. So chips needs satisfiers, which are positives, proposes to satisfy the need of others.
Yes.
And its effectiveness comes in, it's seen as valuable, more valuable by one party to the other, without undermining its own interests. So it's basically, again, we are looking at towards a win-win situation. So chips looks at that way. And chops is basically a negative side of it, which need thwarters, such as threats and insults. So generally it's discouraged, as it encourages competition and undermine trust. And if there is a competition, then negotiation gets into a conflict zone again.
Exactly, yeah.
This is what the basic idea I had.
That's a very new term that I've come across. Thank you, Mr. Raj.
I actually learned it from Mr. Tony Bourne, who's from Scotland. He's basically gave us a training on negotiation skills. So I was remembering him. I thought I can get some example from you stalwarts in our industry. So I really want to learn more about those concepts of negotiations. Thank you, Mr. Jawad. Thanks a lot.
Yeah, but this not being a full-fledged training session, this is just about understanding the basic concepts. So that is why I restricted it to 45 minutes. In a full-fledged training, we go a little deeper into these concepts and we try to discuss that.
Oh, I would love to join that kind of discussion.
But this chips and chops is something very interesting. I haven't heard of it before. So this is a very interesting concept.
Yeah, it is, sir. It is very interesting.
Thank you, Mr. Raj.
Thank you, Mr. Jawad. Thanks a lot. Yeah.
Mr. Jawad, there is one more question also. The person is asking, like, I don't know the name of the person. They have just put the question. How to change hard negotiation into soft, and what is the use of that? What is the difference between soft, hard, and how will you convert hard into soft conversation? Soft negotiation, sorry.
No, the concept is that negotiation neither needs to be hard nor needs to be soft. Instead, why don't we make it as a principled negotiation where the focus is on the problem? The approach is a problem-solving approach rather than a blame game or a competitive approach where winning and losing is the objective. So you change that and you make it a principled negotiation where your objective is to solve the problem, reach a goal that would be beneficial for both sides. Okay. And in the process of it, come up with something with solutions that could be innovative, that would be acceptable to all, that would not that would expand the pie, that would, be beyond what is on the table, bring in more, add more value to what is being discussed. So that is what is called as principal negotiation. So soft negotiation is where you make concessions too easily, right? And
Yeah.
hard negotiation is where you make demands easy. So these are two opposites. So if you're in a soft negotiation, what happens is you come out of it feeling bitter, feeling that you have lost, and with a loss of self-esteem also, because you feel that you have given in too easily. And in a hard negotiation, you end up also getting bruised, while the other side also ends up getting bruised, because both of you are unable to reach an agreement that would be beneficial for both parties. So either one person wins or the other person loses, or both of you lose.
So the next question is from Siri.
Yeah.
The question reads as, while we use technique of Bhatna, Vatna, and Malatna,
Yes.
it sounds as if we are suggesting how to come out of this feeling. This is from
I love the question. See, this is a very common question that is asked, because as we understand it, the mediator's role is not evaluative, it is facilitative. So we keep saying that mediators are not supposed to suggest anything or, tell the parties what to do. But in mediation, a good mediator knows how to ask questions. Now, for example, if somebody tells me that, okay, my lawyer has told me that I have a very good case, I have a very strong case. Now, I'm not going to tell that party that, look, maybe you have a strong case, but it's going to take you a very long time, and it's going to cost you a whole lot of money, and you don't even know whether, you'll be really getting the relief or not. I won't be saying that to the party. That would amount to a suggestion. And if I say that and tell the party that, look, because of this, you should settle. Now, that's a suggestion. Now, if I ask the person that, well, it's very good to hear that you have a very strong case, but can you help me to understand how long this case is going to continue? When do you think you will be getting the final relief from the court? Can you tell me how much this is going to cost you, or how much has it cost you so far, and how much is it going to cost you in the future? Can we discuss how this has affected you personally? The existence of this conflict. How would you feel if this was behind you and it was over? Now, this is how we do the testing. Okay, we are not suggesting, we are asking questions. We are opening the people's mind and making them think about it. So then they start thinking that, yes, this is my alternative, but is it really a good alternative? What happens if I walk out today? What am I getting into? I hope that's clear, Mr. Venugopal.
Mr. Jawad, there is one more question actually. Mr. Mohan is asking, sir, what are the signals where negotiation is going towards conflicting zone? Would appreciate if you can give us with some example.
I think one of the best indicators is that parties are entrenched in their position. When they're refusing to move from their positions and examine their interests, if you're asking them the questions that what is very important for you here? Why is this important for you? And they say that, look, this is why this is important for me, and I'm not going to budge from this, and this is what I want. Now that shows that, okay, they are moving towards the conflicting zone, or rather they are already in the conflicting zone. Now the question is, how do you move them beyond that? That is when you start testing that, how are you going to achieve this? What are your plans? How do you think you're going to realize this amount or this particular thing that you're asking for? How is it that you're going to get it? What is your plan of action? So how much is it going to cost you? Is there anything that you would like to explore to see whether your real interests can be met? So basically, a mediator's role is to help the parties to look beyond that conflict, to look beyond the person, and to look at the problem and see how the problem can be resolved in a manner that would be best for both sides. I think before that also there's one question. Mr. Mohan, is it?
Yeah, I'm coming to that, sir. The question is from Shobha.
Yeah,
She's putting it, sir, in negotiation theory,
yeah,
the best alternative to a negotiated agreement or BATNA refers to the most advantageous alternative course of
Yes.
action a
Yeah.
party can take. And if
Yeah.
the negotiation fails and an arrangement cannot be reached, would you agree that a strong BATNA can also help a party understand that it has an appealing alternative to the deal and can walk away from the tempting offer?
Yes, first of all, Shobha, thank you for calling me a professor, though I'm not. Okay, but you're absolutely right. See, if the BATNA is really strong, if the party has a very good alternative to what is being offered on the negotiating table, why should you accept that? Unless and until that alternative is not really that appealing, or it really has some pitfalls or it has some loopholes that you may not have thought of, and which perhaps the mediator can help you to understand through a set of skillful questions that a mediator puts to you. So once you realize that you don't have the BATNA that is as strong as you thought it to be, why not discuss the deal? Why not negotiate for a better offer? So a strong BATNA is definitely something that will dissuade a party from going for an agreement through the negotiation process. But the question is the BATNA really BATNA? Is it the best alternative? Now that is where the mediator's role comes, where you help the parties to test their BATNA and to understand whether their perception of their BATNA is really the right one, is correct.
We don't have any more question.
Sir, just one question from Mr. Pranav Rana, who is sitting next to me. He
Okay.
wants to know that up to what extent a mediator can enter into bargaining from the parties. Is there any limit, or is there any line we have to draw in between negotiation and bargaining from the parties on behalf of one party to the other party?
Well, that's a good question, because there is no limit at all, for the simple reason that the mediator cannot bargain at all.
Yes.
The mediator can simply facilitate the bargaining between the parties. The mediator can convey the offers after testing them. But beyond that point, the mediator cannot go and tell the party that, look, I'm representing so and so, and here's the offer, and why don't you accept it? So that's not a mediator's role. So the best thing that the mediator can do is, if a party is making an offer, sit with the party, see whether the offer is something that is realistic, something that is achievable, something that is specific, test the offer, and then ask the party, can I convey this offer to the other party? And then you take the offer to the other party. And if the other party has three options, either to accept the offer, or to reject the offer, or to give a counter offer. So if the party accepts the offer, you have an agreement. If the other party rejects the offer, then you ask the other party, so what is your counter offer? And if the party already has a counter offer, you test the counter offer with the party and then take it back to the first party. So basically, you keep shuttling between both the parties, but you don't bargain on behalf of any of the parties. That's not your job.
Thank you, sir. Any other questions, sir?
I don't think we have any other question. Mr. Jawad can proceed.
I hope we finished on time, Mr. Rakesh.
No. I thought you wanted to, you said that you will elaborate something more after the questions. You like to take some more time?
No, if there are any, I think Mr. Rajput has some question.
Okay.
Mr. Jawad, in fact, I was thinking that
Yeah.
a lot of times when we are meeting between the parties,
Hmm.
the parties most of the time, which I have seen and I have experienced as well, they
Hmm.
do when they have it offer on the table or the whatever agreement or the thoughts which they have on the table, they normally ask the mediator itself, "Aapko
Hmm.
kya lagta hai? What do you think? Do you think it is good?" It is very normal from a human to ask the other because they feel that person is an authority. He might be
Yes.
able to give some light. And we normally, as a mediator, we cannot give him that kind of suggestion. We only try
Yes,
to tell him
exactly.
that this is your decision. You have to weigh the pros and cons of this. You have to
Yeah.
decide it. So we normally do that. But a lot of
Yes.
time, the clients get so confused. He's not able to take the decision, and he's
True.
again and again
True.
keep on asking,
True.
"You tell me, is it good or is it bad?" So it actually prolongs the time, and it is sometimes it's okay, we are wasting the time as kind of stuff because we are not coming to the final decision. So how do you actually break that mindset from the client's mind?
Yes, Mr. Rajput, I think the temptation is very great because you are also in a hurry to close the mediation because you're right there. And if you tell the party that, look, I think it's a good offer, why don't you accept it? Perhaps the party might accept it and you can quickly close the mediation and have a settlement. That temptation is a quite a great one for mediators, but that is not what a mediator should be doing. Regardless of the outcome of the mediation, I think the mediator should very politely tell the party that, look, it is a problem that you are facing, and it is something that you need to decide
Yes,
as
true.
to whether it is good for you or not good for you, because I cannot live your life. I cannot substitute my thinking or my feelings for what you must be feeling or going through. It is your experience, it's your decision, and therefore it has to be something that you have to take a call on, and it's something that I cannot help you on.
Yeah, we have to just
So
make him calm on
yeah,
that,
maybe
and
you can even
make him
you can even tell them that if you are not able to decide now, take your time and perhaps
absolutely.
discuss with somebody
Yeah, consult
within
somebody
your
at your
family
family or
or
something.
some advisors who may be there. You discuss with them and come back.
Sure. All right.
But it's always very risky for a mediator to say that, hey, look, this is a good deal. Why don't you go ahead and accept?
Yes, sir. I know. We know that.
Yeah.
Sure. Thank you,
Because
sir. Thank you, sir.
then the concept of self-determination gets violated. I think
Absolutely.
in ethics and confidentiality, there was that self-determination aspect that was discussed. Right?
Very true, sir. Very true, sir. Thank you. Thank you, sir.
Sir,
There is one, yes, please carry on, sir.
there's a question from Shirin Kojuria.
Yeah.
He's asking, can a mediator also ask the party to discuss with his advocate if he wishes?
I would rather urge the mediator to ask the party to discuss with his advocate, because advocates, if they are there, if they are part of the process, they are very integral to the process, and their role becomes very important because they enjoy the trust and confidence of their client, and they understand legal implications of what the clients are going to be agreeing for, and they would be the best people to advise the clients on whether to accept or reject the offer. So I'm a firm believer that if a lawyer is involved in the mediation, the lawyer should be involved from the inception, from the word go till we reach a settlement. So it helps a lot. It also, creates a comfort zone for the parties because they see that their advocate is there and nothing is going to happen to them that their advocate will not be taken care of. I think there's one more question, sir, from
there is one more
Travaso. Is the caucus session useful to negotiate rather than face-to-face negotiation, since parties may feel comfortable to speak to the mediator in private? Mr. Savio, I think that there are different schools of thought on this. There is a school of thought which feels that there need not be private sessions or caucus sessions at all, for the simple reason that it's the party's problems, and why should anything be confidential from them or between them? So therefore, there is a school of thought that believes that everything should happen in an open joint session between both parties. There is also a school of thought that feels that given the kind of human frailties that we have in the form of our cognitive biases and the emotions that we go through, it is always better that the decision takes place between the parties when they're in private sessions, and the mediator acts as a shuttle diplomat, carrying the offer from one party to the other, testing the offers. Because what happens is, because of these cognitive biases, sometimes in a direct negotiation, parties may, even though an offer might, for all intents and purposes, from a very objective perspective, might be a reasonable offer, but just because it's coming from the other party, they may simply reject the offer. And there is no opportunity to also independently test the offers. And there's also a lot of posturing that might be happening between the parties. So where the party may not be willing to make concessions the way they would be doing directly with the mediator in a private session. So there are two schools of thought. It depends on what you choose to do. Now, for me, I would not ask you to do. The best thing is for you to decide on the as you're doing the mediation, see how the parties are, and decide which would be the best process for you to follow. There are merits and demerits in both. So ultimately, you have to choose based on how the parties are receiving.
Mr. Mohan is asking which one of these two school of thoughts is most popular.
See, Mr. Mohan, in the facilitator mediation style, this shuttle mediation is a very popular one in many jurisdictions. For example, if you go to the US, they believe in, I'm told that they don't believe in shuttle mediation. They believe in joint sessions throughout. But if you come to perhaps Europe or some other UK, in all these jurisdictions, people follow, this is what I heard from some of my colleagues and people who are known to me. They believe that, it's better to have shuttle mediation. So it's ultimately, it depends on the situation. I guess it's a call that a mediator may have to take, perhaps, based on how the parties are interacting with each other. So if you're able to take the parties to a level where they are able to interact with each other, and you're able to create that safe environment where they are able to exchange offers without getting offended or without perhaps reacting in a hostile manner to a particular offer, then I would suggest that you go for a joint session throughout. But if you feel that the parties still have some reservations about these things, and you feel that it's better to do a shuttle mediation, so be it. Now, I personally, what I normally follow is shuttle mediation, because most of our mediations in India, we have a very volatile situation there, and there is a lot of emotions, and especially where relationships are involved, people become very what should I say? They react very badly to offers that come from one party when they're in a face-to-face situation. But if the same offer is conveyed by the mediator, they are more open to listening to it. So I find that to be very effective in the Indian context. But again, it is not one size fits all. Okay, it depends on how the parties are and what situation they are comfortable with, and what process they are comfortable with, as well as what process you are comfortable with.
There is one more question, Jawad. This is from Abha Sharma. In a virtual mediation, what I have experienced, it is very difficult to understand how much the parties are convinced, the process of mediation, how to evaluate the situation.
In a virtual mediation?
Yes, yeah. In a virtual mediation, what I have experienced, it is very difficult to understand how much the parties are convinced, the process of mediation, how to evaluate the situation.
See, in a virtual mediation, I think one of the challenges is you are not able to observe the body language of the parties, and it kind of creates a situation where you really don't know what is going on in their minds, perhaps. But what I have found is that while there are some problems with virtual mediations, from this, that there is no personal touch there, and because like you're not able to share a cup of coffee with each other, you're not able to offer a box of tissues to a party who's becoming emotional. Okay, so these are some of the drawbacks. But the other advantage is that it is time agnostic, space agnostic. So you can sit anywhere and do the mediation. Parties will be sitting in the comfort zone that they are happy with to be in, and you can mediate. Usually people feel that family mediations, matrimonial mediations are very difficult to resolve over the virtual medium. But I have found them to be, I have found the response much better online than in person, for the simple reason because sometimes there might be so much of hostility between the parties, or a sense of insecurity might be there, a sense of danger might be there, where one of the parties may feel uncomfortable sitting in the presence of the other party and discussing anything. So this gives them a kind of a feeling of comfort and security when they are sitting in their homes, surrounded by their own people. So they don't have to really sit face to face with the other person and talk. And of course, you can always do the shuttle mediation, but considering the kind of infrastructure or the lack of it that is there in our courts, it becomes very difficult to do these separate sessions because parties have to cross each other at least when they're coming in and going out. Whereas in other jurisdictions, what happens is they put the parties in two separate rooms and the mediators keep moving from one room to the other. Whereas we don't have those facilities here. So until we are able to get that kind of infrastructure, it becomes an issue. But I feel that, I have not felt that challenge in online mediations personally. I've been very comfortable doing online mediations. But Abhaji is right in the sense that it is very difficult to understand what exactly is going on in the minds of the parties. But you can ask questions, by asking questions. What do you think about this? Help me to understand how you perceive the situation. Or perhaps you can ask a question like, what do you think about the present situation? What are you feeling about it? Help me to understand that so that I can, maybe help to take this forward in a better way. So ask those questions, build the rapport with them. Now, see, I have conducted mediations online and also training programs online. So, for example, when the Maharashtra National Law University wanted me to conduct the first paper, Amrita is here, and she was one of the participants in that. And we did a full paper on mediation, the basics of mediation online, spread over a period of 1 month. And the kind of rapport that we could develop online was something amazing. I mean, we did not meet each other face to face, and we had no occasion to, really shake hands and share a cup of coffee, but still we could establish a bond with each other. Okay, so and that was a very strong bond. And when I happened to go to Bombay once, the first batch people had all come to see me in spite of the heavy rains and in spite of the distance that they had to travel. So I think we need to remove from our minds this mind block that we have that, okay, on the digital platform, it's difficult to establish rapport because this is going to be the future. Okay, online dispute resolution is going to be the future because the younger generation simply don't have the time or the patience to, travel long distances and go and sit in one place and, discuss anything. They would prefer to, today I chat with my grandsons on WhatsApp because they're so busy, So this is something here to say. We might as well accept it rather than, resisting it. That's what I personally feel.
So there is one more question from Sunita Chaudhary.
Yes.
He asks if an advocate gets involved during the mediation process, would they affect the mediator's role?
No, I don't think so. See, one is the we need to understand the advocate's role in the mediation, because they are they are an integral part of the mediation process for the simple reason because they enjoy the trust and confidence of the lawyer. Now, in one of the webinars that I was speaking on, a mediator told me that they had reached a settlement, but the advocate stopped the settlement from going through. And I asked why, and she said that she had asked the advocate to stay out of the mediation. Now, let us remember one. It is not just the advocate, but every person who has a role in the decision-making of it. Now, particularly if you take matrimonial mediations in the Indian context, because we do a lot of matrimonial mediations in the court system. So let's understand one thing, that if you keep any of these stakeholders outside, because marriages in India take place not between two individuals, but between two families. So the father, the mother, the uncle, the aunt, the brother, the sister-in-law, everybody has a say. Now, if you feel that if somebody has got some influence on the party, no matter how much you try in the mediation, they will go back, discuss, they'll come back and they'll say sorry. So might as well involve them in the process. So why don't we just suggest to them that, okay, who's important for you? Who would you consult in this matter while you're taking a decision? If they say the father, then we would like to invite your father to be a part of this process. So when you're inviting a third party, why not the advocate? Now, if you stop the advocate from taking part in the process, you're never going to get a settlement, or you're never going to help the parties in reaching a settlement, simply because the party will be leaving the mediation room and going to the advocate's office and telling the advocate that this is what I was offered. And the advocate is going to tell, sorry, I don't think you should accept this. Not with any ulterior motive, but because of the simple reason that the advocate was not involved in this process of how this offer came up. So the advocate simply does not understand the rationale behind it or the reasoning that goes behind it, or doesn't have that kind of clarification or justification for the offer. So the advocate looks at it from a totally different perspective and says that, look, this is not going to help you. So sorry, don't accept it. So I would rather say that involve the advocates. Now, what is most important is when the advocates come for the process, I always thank them for coming. And I tell them that I need your help in this, because you are the ones who are going to guide me in this process, and you're going to be guiding your clients in taking the best decision possible for them. And I tell them that thank you for encouraging your clients to come for this meeting. And I tell them that I understand that you're very busy, but I would request you to be a part of this process from the beginning to the end, because I will be looking to you for guidance. Now, this makes them feel happy, because when they come, I'm a lawyer from the same court. They look at me as a competitor. So when I give them the importance, so I'm respecting what is called the scarf. Status, certainty. David Rock came out with a paper. It will take quite a long time. It's based on neuroscience, where if a status of a person is violated, you feel the same threat or reward response that you feel when you are under a physical threat or attack. So respect their status as the advisors of the parties and encourage them to be a part of the process. And they can be, they can really be an asset for you in helping the clients to reach an agreement.
Sir, I agree with you. Recently, in a mediation between a husband and wife who was wanting, who was really fed up of the husband, but she was not able to take a decision. So I requested her advocate to kindly assist, and I told her, please have a session with your advocate before we meet next time, please spend an hour with your advocate. He is very matured and he will explain you so that you can take a decision what you want. You want to live with the person because the husband says, I'm ready both ways. Whether if she wants to come and live with me, I'm open for that. If she doesn't want to live with me, I'm open for that we will part ways, but amicably. So I explained it to her and I requested her to spend time with her advocate. She sat with the advocate, and to my utter surprise, the very next sitting, the solution came. And you see, the advocate advised her, and they decided that they will part ways with each other.
Yeah.
And the settlement came through. So yes, you are absolutely right. There is a big role of the advocate, and you are absolutely right that you see the confidence which they have in their advocate.
Yes, sir.
Is really something which we can't replace by any other role.
Not at all. Not at all.
Especially they feel that mediator at times they take it that every party thinks that we are taking the side of the other party. So if their advocates are involved in between, I also feel that advocates play a great role and they help us to reach to a solution. Because the parties have more faith in their own advocates than in us, the mediator. They feel that no, whatever we are saying, even if we are trying to explain them legal situation, they will not believe unless and until their own advocate will say, this is the legal situation. Then only they will trust.
The advocate's role becomes very significant when you are discussing the Vatna and Vatna with the parties.
Yes.
Because if it is done in the presence of the advocates, the parties understand that yes, this is correct. So I think we need to resolve this. So Mr. Amin Merchant, thank you for explaining the scarf model.
Okay.
So any other questions?
I don't think so. There is anything more. There is one, actually somebody has written, and I just wanted that you should also give your opinion about that. Mr. Mohan says, I feel ultimately decision makers should be part of negotiation. The negotiator should be empowered to take a final decision and sign agreement. How much do you, what is your opinion about that, Mr. Jawad?
No, that is what I said just some time back. No, I said that it's very important to involve the ultimate decision makers, because in many times we find that the parties before us may not have the decision-making power, and they have to go back to someone who will be the person who will be pulling the strings ultimately. So instead of having that back and forth, why not invite them to come in and be a part of the process directly, so that they know what is happening. So that gives them a sense of comfort, a sense of importance, and a sense of responsibility also, because then they realize that, okay, we need to guide the person who's dependent on us in a right way. So somebody has asked for an explanation of the scarf.
Yes.
Well, that will take, I think, another about at least 5 minutes. Is that all right? 5 to 10 minutes? Will that be all right? You have the time?
Yes.
Yeah, okay. See, basically, neuroscience has shown that there is a bunch of neurons in our brain called the amygdala. Now, this amygdala has been found to be a storehouse of our emotions. And these are the emotions these emotions are basically responsible for our survival, because when you feel the emotion of fear, you run away from them. When you feel the emotion of anger, you defend yourself or you attack. So these are very primitive feelings that are stored in our mind, in our brain, in this amygdala. So whenever any signal of any threat is perceived, that goes to the thalamus, and from the thalamus there are two signals that they get bifurcated into two. one goes to the frontal cortex, which is the rational brain, which processes the information and decides what is to be done about it. The other part of it goes in a shorter and much faster way to the amygdala. And the amygdala starts reacting much before the frontal cortex responds. So supposing you see a stone coming your way, which is being thrown at you, you don't think twice about it. You simply duck. You avoid the stone, or you just put up your hands. That is your instinct. That is the amygdala triggering you to react. Now, what happened is in 2008, David Rock came out with a paper where he said that there are 5 social domains that trigger the same kind of threat or reward response that any physical threat or reward would trigger. So he said that one is status. So he called it the SCARF model, SCARF, which is an acronym for one, status. So when your status, supposing somebody, if Manjula said nice things about me in the morning, now I felt good about it, right? So it shows that, you know, my status is respected and acknowledged. Now, if supposing somebody were to insult me, I would feel humiliated. I would respond with anger. So status is something. It is a perception of ourselves, how we perceive ourselves, and when we feel that perception is violated by somebody, we feel the threat. So our amygdala gets triggered. So also certainty. Now, knowledge of what is going to happen in the future. Why do we go to astrologers? To know about the future, right? I mean, I don't go because I want to take every day on its own. So, but I'm saying generally we have this curiosity about the future, and whenever something threatens the future, that future, like supposing if I don't know whether my wife loves me or not, it creates a sense of uncertainty in my mind, and that triggers my amygdala. So I start reacting. The third is autonomy. We all like to do things the way we want to do, the way we when to do, how to do, what to do. We like to have that kind of freedom, right? It is a sense of autonomy. And if that is violated, if somebody keeps telling you, don't eat this, don't eat that, don't dress like this, don't go there, don't go here, it happens in relationships, right? So people don't realize that you're actually impinging the autonomy of the other person. And that is going to be triggering a threat response to that person. So autonomy, relatedness. We are basically social animals and we like to relate to each other. And whenever we feel that we are being treated differently from the others, or we are being not being included as part of the pack or the group, we feel, we feel threatened by that. So, for example, if supposing there's a cricket team and they're in the locker room and discussing something, and one of their teammate walks in and they stop talking, and they look at each other, and there's a gesture which is being made that keep quiet. Now, how will this teammate feel who has walked into the room? So he feels unrelated to them, and he feels left out. He feels like an outcast. That creates the threat response. The fifth is fairness. Fairness is again, it's a very subjective thing, what we perceive as fair to ourselves, right? So whenever that fairness is violated, we feel that someone has been unfair to us, or we have been deprived of something that we are entitled to. That again triggers a threat response. So what David Rock said was these 5 domains we need to look out for whenever they're in a conflict situation. So in the mediation context, as mediators, when we are in the stage when we are trying to understand the background of the conflict, when we are trying to understand what has led to the situation where the parties are in conflict, we always keep looking for these domains to see which domain is actually violated, which domain has been affected for this party. Okay, whether it is the status, whether it is the certainty, whether it is the autonomy, whether it is the relatedness, whether it is the fairness. So we try to see that and see how we can address through opening up the communication channels between the parties, help them to understand why this communication has to be modified, or what kind of process they have to agree upon. So we try to rectify the situation once we understand it. So it becomes important for mediators to understand where the conflict conflict is coming. So one of the sources of conflict is the violation of the scarf. So I hope I didn't take too much of your time. Sorry.
No, Mr. Jawad, with this, I'll say that there's no more questions right now. Whatever questions, if somebody is having, please put in the chat box. We'll try to answer those questions, and very soon Mr. Jawad will be in touch with you for those questions. And with that, I thank you very much, Mr. Jawad. It was a very nice, very interactive, and I'll say very informative session. You explained everything very nicely. Thank you very much from my side, from Nivaran's side, not from my side only. And I invite Mr. Rakesh Khanna to say few words and to give their closing remarks. Over to you, sir.
Thank you very much, Manjula. Before I start my closing remarks, let me recognize the presence of some of the eminent persons in today's session, especially Rene Baptiste, Archana Medekar, and Sarah. Let me put it, if I borrow the words of Manjula, these are some of the flowerists who have already exhibited their flowers by their talks in this summer school. Thank you very much for your presence. If I put the crux of what Mr. Jawad has, in his eloquent lecture today, has talked about, and if I have to put the negotiation in his words, I'll put it to say, negotiation is a dialogue between two or more people or parties to reach a desired outcome regarding one or more issues in a conflict. This, I think, is the crux of what is the essence of what Mr. Jawad has put today. Each one of us have seen a beautiful picture behind Mr. Jawad, picture of a path, beautiful path, taking us, and the path from which Mr. Jawad has taken us to the knowledge park on the field of negotiation today. Thank you, Mr. Jawad, for the... No one could have explained the concept of negotiation and its techniques better than Mr. Javed. Mr. Jawad, his experience as a mediator, as a trainer, is amply reflected in the talk he delivered today. Negotiation and bargain is an inevitable part of everyone's quotidian life, whether we go to shop and try to negotiate with the shopkeeper, or whether we hail an auto and try to negotiate with the driver, whether we try to sell our car, as Mr. Jawad has put as an example. At each and every such transaction, one common thread that prevails will be always that the price is finally paid, that which has been mutually agreed upon. That said, I must compliment Mr. Jawad for the way he succinctly introduced the concept and techniques of negotiation today. I'm sure everyone here shares the feeling that we were all oblivious of the fine nuances of negotiation until today. I, on my own behalf and on behalf of Nivaran, as well as that of all participants joining us today, thank Mr. Jawad for his eloquent discourse on today's subject. Thanks to all participants for joining today's lecture, especially from Indian jurisdiction today being a festival of Raksha Bandhan. All my sisters sparing time and joining, all kudos to them. Special thanks to Mr. Rahul, a budding advocate who has recently got registered and who has been the backbone of all the programs conducted by Nivaran till date. When he was a student, we started the Nivaran programs 3 years back. Each and every program, Rahul has been the main support to Nivaran. We also like to thank Rohit, a promising law student, for both of them successfully and dependably providing us all the logistic support for all our programs, and especially this international virtual mediation summer school. Thank you all. We look forward to see you all the participants again tomorrow at 5 p.m. for yet another interesting lecture by Andrew Miller on the topic online dispute resolution, which has proved to be one of the most relevant and purposeful methods of mediation during the pandemic and also for resolving the cross-border disputes. Thank you all and good night from India.
Good night, everybody.
So thank you everyone for patiently listening, and thank you Nivaran once again for the opportunity. Thank you.
Thanks, Jawad. Thank you very much.
Thank you, Santan.